Hello and welcome to Session 6 of our Series 7 exam overviews by Passing Score. In this video, we'll be going over all the rules around registered reps. This includes who principals are, muni reps, supervision, disputes, and how those disputes and violations get resolved. Let's start with what a registered rep is. It's anyone who solicits business, trade, underwriting, transactions with securities, someone who has filed a U4 form with FINRA and then passed the appropriate licensing exam. Non-FINRA firms can have registered reps. They would just file a U10 form instead. A principal is someone who has overall responsibility for the broker-dealer. This includes the owners, the senior management, directors, and partners of the firm. They file a U4 form as well, but they must pass an exam called a Series 24 in order to be a principal. And this is true for FINRA or MSRB member firms. Muni reps have the U4 and the Series 7 that they can take, or they have the option of passing the Series 52 exam, which focuses specifically on muni securities. In any case, they're subject to a 90-day apprenticeship under which they cannot receive commissions and cannot deal directly with the public. There are a lot of supervision rules when you're running a broker-dealer, and these procedures in compliance with FINRA and SEC rules and any other rules must all be written down. An officer must be designated who's in charge of all the OSJs for the broker-dealer. An OSJ is an Office of Supervisory Jurisdiction, basically any branch or office of the firm that takes new orders, sets up new accounts, does trading on behalf of clients, anything that would be subject to regulation by FINRA. There needs to be records of the supervisory procedures. Any rep correspondence needs to be reviewed and endorsed, as well as any transactions. Customer accounts need to be approved, and any abuses should be reviewed periodically as well. At least once a year, every OSJ should be inspected, and any qualifications and monitoring of activities of reps should be examined periodically as well. Continuing education is required to keep your license 1 year after you initially register, and then every 3 years afterwards. This training involves regulatory, ethical, sales practices, all of the normal issues that needs to be reinforced periodically. If you don't do your training within 120 days of your anniversary, you may not be able to perform certain activities or receive compensation that requires registration. So you probably need to comply with that. Firm element training is the training that's done by the broker-dealer for their own employees, their own reps, and this needs to be done at least annually. Compensation is restricted for non-registered employees of other member firms. Now, if you're dealing with other registered employees of firms, commissions can be split and there can be certain arrangements, but non-registered employees are watched much more closely since they're not licensed to receive commissions and trading and shouldn't be involved in those kinds of activities. There are 4 criteria that must be met for non-registered employees to receive compensation. There must be a written agreement as to the nature of the employment. The exact compensation needs to be detailed. There needs to be consent from the other firm, and any gifts and compensation are then recorded. Referrals can be made by non-registered employees, but they can't receive any compensation or gifts for that. The customer that gets received over to the member firm can receive some kind of bonus or compensation for joining the firm. There's no issue with that at all. Certain activities can be sensitive for a broker-dealer, so written permission must be given by the firm for any outside activities that their employees, their licensed employees, perform, and the firm can prohibit any outside activities. This can be membership on a board or working for another company. This is to avoid any perceptions of conflicts of interest or real or perceived biases by the employees to favor certain companies or clients because of their relationships to them outside of the firm. Representatives are also limited in sharing profits with their clients as well. They must follow these 3 rules. They must make a financial contribution to the account, and they have to share in the profits in the account in proportion to that contribution that they've made. In addition, the firm has to give its approval as well. Again, this is to avoid any real or perceived conflicts of interest when dealing with certain accounts. Complaints are made through the Office of Disciplinary Affairs. The respondent is the broker-dealer who the complaint is against, and they must respond within 25 days, or basically they've admitted that they're guilty. In addition, they need to request that they get a hearing by a hearing panel, so they're pretty much going to do that. So within 25 days, the respondent will typically respond and request a hearing from the hearing panel. The hearing panel is made up of the hearing officer and 2 panelists appointed by the Chief Hearing Office. If you don't request a hearing, you waive your right to it, so pretty much that's going to get done. The hearing panel has the power to do pretty much anything except for imprisonment. Since they're not a court of law and this isn't a criminal procedure, this is a hearing panel for an SRO, a self-regulatory organization, so they can do things within that purview, which includes censure, fine, suspension from the group, expulsion, and just about any other suspension or punishment that they deem appropriate short of imprisonment. The respondent has 25 days to file an appeal with the NAC. The NAC can again do pretty much anything: affirm, reverse, modify, increase, or reduce the sanctions that have been made. If the broker-dealer doesn't like the decision by the NAC, they can appeal to the SEC. The SEC will review their case and give their opinion as to affirming or modifying the decision. If the broker-dealer still doesn't like the SEC decision, they can file a suit in federal court and continue up through the legal system that way. An AWC is kind of like an expedited procedure to resolve this kind of any violations that are issued by the Department of Enforcement. An AWC lists out the rules that are violated and any sanctions imposed, and waives the right to appeal. If the broker-dealer signs off, you're pretty much done and the violation is complete as to the process. And this can be no more than $2,500 and censure. So this is not for very serious violations, but things that can be resolved rather quickly. Now there's 2 types of codes that FINRA lives by. There's the Code of Arbitration. This is settling of disputes, so arguments between member firms, arguments between members and the clearing corporation that they work with, and arguments between the firm and its own clients, provided that the client has signed to give their written consent ahead of time. A Code of Procedure are disciplines for violations of rules and regulations, which we just talked about. Now, a Code of Arbitration means that we're going to have an arbitrator that goes through and hears both sides. So we have a Code of Arbitration and a Code of Procedure that we'll have to remember for the exam. There's a National Arbitration Committee that handles any of these issues that are done through an arbitrator. Now, if the issue is greater than $50,000, we're going to have 3 arbitrators that decide on the issue. Anything less than $50,000 involves just 1 arbitrator. And because the members going into the arbitration have agreed to ahead of time, the decisions made by the committee are final unless there's some law overruling them. So remember, if the issue involves greater than $50,000, there are 3 arbitrators. Less than $50,000 is going to be 1 arbitrator. That's it for our Registered Representative section overview. If you have any questions or comments, please feel free to email me at john@passingscorefinance.com. And good luck on your exam.